All right, so I'm going to be talking about competency restoration. So before I begin, I just want to introduce myself. My name is Garrick Bollier. I am born and raised in Jersey, but I currently reside in Mount Rainier, Maryland. I'm currently a PsyD student studying clinical psychology. I'm a third year. I'm about to be a fourth year by mid-June. I attend the Chicago School of Professional Psychology on the DC campus. In regards to some experience, I've externed at the DC Superior Courts, doing clinical assessments. I have externed at St. Elizabeth's Hospital, which is a hospital down in DC, and I've just been recently accepted at the DC VA, so I'm really excited about that. I'm currently the education board member at the MPN, and yes, that's a little bit about myself. In regards to questions and things like that, I'll just wait to answer them once everything is done, once I'm done with the whole presentation. In regards to the agenda, I'm gonna give you a brief background of St. Elizabeth's Hospital, which is the hospital I just externed at. I'm gonna discuss competency restoration in regards to St. Elizabeth's Hospital. So, competency restoration can vary throughout different hospitals, throughout different states. So, I'm just doing competency restoration in the context of my specific hospital, and so certain rules may be slightly nuanced or different in other places. I'll discuss Dusky versus the United States. I'll discuss what the difference is between competent and incompetent, different types of pleas, Bolton versus Harris, Jackson versus Indiana, crimes and penalties, a wrap up, and then we can go to questions. So, in regards to competency restoration, in the context of St. Elizabeth. So, to begin, St. Elizabeth, a little background about St. Elizabeth's. Also, I'm gonna be calling it St. E's. That's the little nickname for it. So, St. E's was founded by Congress in 1852 through the efforts of Dorothea Dix. St. E's is in Washington, D.C., and it's a publicly funded inpatient psychiatric hospital with approximately 300 beds distributed between 12 forensic and civil units. St. E's was America's first federal mental health hospital, and it was the first public mental health hospital in the District of Columbia. In regards to the population, it's predominantly severely mentally ill urban minority patients. So essentially, why would you be at St. Elizabeth's? So you would be charged with a crime. The judge will feel that you were not ready to go any further in the legal process. The judge will base their decision on the information from the evaluator, which could be a psychologist or psychiatrist, who thought that you might have a mental illness that prevents you from helping a lawyer, from you helping your lawyer defend you. Having a mental illness could get in your way of having a fair trial, and at some point during the legal proceedings, everything had to come to a stop during your competency being raised question. So then the judge will then commit you to St. Elizabeth so that your treatment and training will be competent for you to proceed with your charges. Now, you sometimes if your mental illness does get in the way, you may not get sent straight to St. Elizabeth's. You can be ordered to an outpatient competency restoration program, which is called OCRP, and you will only be sent there for an outpatient competency restoration program if the judge thinks that you can live at home and attend all your classes at OCRP. And if you are not psychiatrically stable, so if you're not psychiatrically stable, you're not attending all your classes, and or you're not trying your best, then you'll be sent to St. Elizabeth's. So basically, if you're able to function and be stable enough, then you can still live in the community and then just attend the classes to become competent. But if your symptoms are too severe, then you'll go straight to St. Elizabeth's and then you'll receive treatment and training there. In regards for the timeline for competency restoration, your first competency evaluation at St. Elizabeth will be 30 days after your admission. So what happens after that evaluation? The staff will write a letter to the court stating if they believe you're competent or not, and then the court makes the final decision. If you're not competent, then you'll return to St. Elizabeth for some more treatment, and then you'll have another court date, and the evaluation is scheduled. Another evaluation is scheduled, which is usually another 30 days. If you are competent, then the court sets a date for a plea hearing. So, a difference between competent and not competent. So, you're competent when you know your charges, when you know the court proceedings, you know the function of the people in the court, such as the judge and jury. You're able to cooperate with your defense attorney. You know what the police said you did. You know the pleas and what you make them, and you know your pleas and what you make them, and you know how to behave in the courtroom. Essentially, to be competent, you must have sufficient and present ability to consult with your lawyer with a reasonable degree of rational understanding and have a rational as well as a factual understanding of the proceedings against you. So I'll elaborate that a little bit more. So a little history. So the Dusky Standard, and this is really the standard when it comes to competency. So Milton Dusky kidnapped a 15-year-old girl and transported her from Kansas to Missouri, then raped her. He was then arrested and he was referred for a mental health evaluation. A psychiatrist testified that Dusky was unable to properly understand the proceedings against him and unable to adequately assist his counsel in defense due to his severe mental illness. Despite the testimony, the Dusky was ruled to be competent to stand trial because he was oriented and able to provide some details regarding the kidnapping incident. Dusky was then convicted of kidnapping and sentenced to 45 years in prison. The court later decided to grant uh, the writ of certiorari, which is essentially the review of the court decision. And then the court ruled that to be competent to stand trial, the defendant must have a sufficient present ability to consult with his lawyer at a reasonable degree and have a rational understanding, as well as a rational and factual understandings of the court proceedings against him. And that is what is known now as the Dusky Standard. The court made clear that a brief mental status exam was insufficient, and Milton Dusky's sentence was later reduced from 45 years to 20 years. So essentially, this guy, who was really unable to really understand, the court proceedings, who was unable and who was really mentally severe, who was severely mentally ill, committed this crime. He was found guilty. However, the at first the court thought that he was able to stand trial because he had a brief mental status exam, and that wasn't sufficient enough for him to continue with trial. So the three main pleas in court: there's guilty, and not guilty by reason of insanity. So if you're guilty, then you're telling the court that you did the crime. So if you plead guilty or you're found guilty, you're either sent to jail or prison. You have probation, which is a sentence in which you live in the community under supervision of a probation officer. Time served, which is the time spent that you spent at St. Elizabeth's awaiting trial, is usually subtracted from that sentence, with only the balance being served after the verdict. Or you'll have suspended sentence, which is really delaying the defendant from serving their original sentence, and then they'll go on probation. Suspended sentence is basically, in other terms, me being found guilty and the judge letting me free and go into the community. Now, if I break the law, the judge will then I'll go back to court and then I'll serve the original sentence of my crime. If you're not guilty, then you're essentially telling the court that you did not commit the crime. If you plead not guilty, then your trial date is set and then you'll go to trial. Not guilty by reason of insanity is that you're telling the court that you did the crime, but you were not at the right state of mind at the time of the crime or offense. You also must have a mental illness. So you can't really say that, you were drunk or you were high when you committed this crime and you'll plead not guilty by reason of insanity. You must have a mental illness for you to be eligible to make this plea. And if you are found not guilty by reason of insanity, you'll go back to St. Elizabeth's for 50 days and then await a Bolton hearing. So what's a Bolton hearing? So Bolton, a Bolton hearing is essentially when the court decides if you are still mentally ill and dangerous to yourself. So it's essentially a risk assessment. If the court decides that you are still mentally ill and dangerous, then you're sent back to St. Elizabeth's for treatment until you're no longer in danger. So essentially, if you found not guilty by reason of insanity, then you go back for 50 days. And then you're waiting a Bolton hearing. So 50 days later, you have this hearing, and then the court will decide, are you still danger? Are you still a danger to yourself or to your others? And if you aren't, then you may be free. If you still are a danger to yourself or others, then you have to remain at the hospital. Next is a Jackson hearing. And this is a hearing one will attend if they are found unlikely to become competent. And this is usually after a second or third failed competency evaluation. This hearing discusses the person's competency and determines if the hospital will seek civil commitment. So possible outcomes of a civil commitment hearing is that you can remain at St. Elizabeth as an inpatient. You are placed in outpatient treatment and released, and or there's no commitment and you're released from the hospital. So Jackson versus Indiana. This is a really interesting case. So of May 1968, Theon Jackson, who was 27 years old, was charged with two separate robberies. He was a deaf mute who cannot read, write, or virtually otherwise communicate. Mr. Jackson was found incompetent to stand trial and was committed to the Indiana State Department of Mental Health, which stands for DMH, to be confined in an appropriate psychiatric institution until he shall become sane. So Mr. Jackson's attorneys appealed to the Indiana Supreme Court in 1970 and then to the U.S. Supreme Court in 1971, which led to the decision of Jackson versus Indiana in 1972. So the doctors report that Jackson's condition prevented his understanding of the nature of the charges against him or participating in his defense, and their testimony showed that the prognosis was rather dim. That even if Jackson were not a deaf mute, he would be incompetent to stand trial, and that Jackson's intelligence was not sufficient to enable him to ever develop the necessary communication skills. Like I said, he was a deaf mute who cannot read, write, or virtually otherwise communicate, and he was assigned to a psychiatric hospital until he's able to become sane. So, his lawyers are trying to plead, saying this guy is not going to become, you know, he doesn't have the mental capacity to, become competent. So, according to a deaf school interpreter's testimony, the state had no facilities that could help Jackson learn minimum communication skills. So again, he's a deaf mute who cannot read, write, or virtually otherwise communicate. And this facility and the state had no facilities to help him even minimally communicate. So after finding that Jackson lacked comprehension sufficient to make his defense, the court ordered Jackson to be committed until such as the health department could certify his sanity to the court. Jackson's counsel filed a motion for a new trial, which was denied. Jackson claimed that the commitment under Indiana law deprived him of equal protection because uh, without the criminal charges against him, the state would really have nothing to proceed against him, who was a mentally ill person. Jackson also asserted that the indefinite commitment under the section deprived him of his due process and subjected him to cruel and unusual punishment. So what does this all mean? Essentially, it held that the state of Indiana cannot constitutionally commit Jackson for an indefinite period of time solely due to the fact that he was incompetent to stand trial because it violates the equal protection and his due process, which is his 14th Amendment. Like I said again, he was a deaf mute who cannot read, write, or virtually otherwise communicate, and the state was trying to keep him confined to the hospital. So a person cannot be held more than a reasonable period of time to determine whether there's a solid chance that they're able to attain competency in the foreseeable future. And if it is determined that he will not, the state must either institute civil proceedings applicable to the commitment of those not charged with a crime or release the defendant. So essentially, if you know there's no possibility that you're able to become competent or recover, then you're either gonna have you're either could be released or the commitment of or not charged with the crime. So types of crimes and penalties. This is usually the last phase of the trial. So in order to become competent to proceed, you must know your crime and how much time it carries. There's two types of crimes. There's misdemeanors and felonies. Misdemeanors are not as serious as felonies, and if you're convicted, you have up to 1 year for each charge. Felonies are more serious, and from 1 year, and each charge, you're able to serve from 1 year to life for each charge. So essentially, this is the wrap up of the whole presentation. So essentially, to be competent, you must have a rational understanding, a factual understanding, and able to communicate with your lawyer. Competency evaluations and regulations may differ than St. Elizabeth's. If one may is able to become an outpatient, if one may be able to attend an outpatient program to become one is a sorry one may be able to attend an outpatient program to become competent. But if you're not psychiatrically stable, attending all your classes or trying your best, then you'll be sent to the hospital. If you are competent, the court will set a date for a plea hearing. If you're not competent, then you remain at St. Elizabeth's for more treatment, then evaluated in another 30 days. A Jackson hearing is basically if you are unable to become competent. A Jackson hearing is basically saying if you're unable to become competent, and they discuss competency and to see if the hospital will seek a civil commitment. A Bolton hearing is when the court decides if you're still mentally ill and whether you're a danger to yourself or others, which is essentially a risk assessment. Misdemeanors, not as serious as felonies, if convicted, up to 1 year for each charge. Felonies, more serious, which is a more serious crime, from a year to life for each charge. And the three types of pleas are guilty, and not guilty by reason of insanity. I actually have a forensic flow chart that would have been really great for you guys to see. But if you guys are interested, just drop your emails in the little comment box, and I'll be sure to send you my slides. Are there any questions? Give you guys some time to process. Are there any assessments or tests, or is it strictly clinical interview? So there are some places do assessments or tests. At St. Elizabeth's, we do have it, but we try to just do the clinical interview. I can actually pull up some of the names of the assessments so you could look it up for yourself. So some assessments are the MacArthur Competency Assessment Tool for criminal adjudication, the evaluation of competency to stand trial, which is the revised edition, competency for standing trial for defendants with mental retardation, the instrument of legal knowledge, which is like a malingering scale. There's also a competency screening test, a competency assessment instrument, interdisciplinary fitness interview revised, and the Georgia court competency test. So yes, there's a wide variety of clinical assessments that are validated to test for somebody's competency. What are some things they do to check if someone is competent? So, for instance, something as simple as, okay, so what were you charged with, and seeing if the person is able to really understand what their charge was. At St. Elizabeth's, we have a lot of people who are psychiatrically unstable, so something as little as the crime that they were charged with is something they may not really understand. um Something else can be, really, like, what is a jury, how many people are in the jury, what does the jury do, what's the difference between a jury trial and a bench trial. Just really knowing the basic, like the really just the basics of the court proceedings, because that's important to know. And another big important thing is really being able to communicate with your lawyer. If you can't communicate with your lawyer, then that's one big red flag that you're not competent to stand trial. um Cooperating with your I said to cooperating with your defense attorney. How to behave in the courtroom as well. If you are really just like wilding out and really just going crazy, the judge can deem you not competent, and then you can be sent to the hospital. Is this something that is utilized in every state? I'm not 100% sure, but the regulations may vary. This is only from the context of the St. Elizabeth's Hospital in Washington D.C., but the laws that were passed are national laws. So Jackson versus Indiana, that's a national law. Gerald Bolton versus David Harris. That's for the Bolton hearing. That's a national law. As far as, and in addition to Dusky versus United States, which is the Dusky Standard. So those are all, you know, national laws that can be instituted, anywhere. All right. Since we don't have any more questions, feel free to, follow the NPN Instagram page and like the Facebook page, and see you guys around.